Welcome to Lawyer Up by NDV Law. I am Atty. Karlo Nicolas, one of the senior partners of Nicolas in the Vega law offices. I am going to talk to you today about the recently approved law allowing a new form of corporation called the one-person corporation. The OPC is a new entity under Philippine laws. In the Philippines, business enterprises are organized principally in one of four forms: the single proprietorship, the general partnership, the limited partnership, and the corporation. However, on February 23, 2019, Republic Act No. 11232, also known as the Revised Corporation Code of the Philippines, took effect and introduced, particularly in Chapter 3 of the law, the establishment of the so-called one-person corporation, who may or may not incorporate as an OPC. Unlike in the old corporation code, called Batas Pambansa Bilang 68, which generally requires a minimum of 5 and a maximum of 15 incorporators in a corporation, a one-person corporation is a corporation which only requires a single stockholder who can be a natural person, or a trust, or an estate. A foreign natural person or a foreigner may also put up an OPC, but subject to the applicable capital requirement, constitutional and statutory restrictions on foreign participation in certain investment areas or activities in the Philippines. However, banks and quasi-need banks, pre-need companies, insurance, public and publicly listed companies, and non-chartered government-owned and controlled corporations cannot incorporate as a one-person corporation. Also, a natural person who is licensed to exercise a profession may not organize a one-person corporation for the purpose of exercising such profession, except as may be provided under another law. Now, how long can a one-person corporation exist? The SEC, or Securities Echange Commission of the Philippines, issued Memorandum Circular No. 7, also known as the Guidelines on the Establishment of a One-Person Corporation. It says that the term of existence of the OPC shall be perpetual. However, in case of a trust or estate, its term of existence shall be coterminous with the existence of the trust or estate. Now let's discuss about the corporate name, director, officer, nominee, and alternate nominee of a one-person corporation. As for the name, the OPC must have a suffix OPC, which should be indicated by the one-person corporation either below or at the end of its corporate name. The single stockholder shall be the sole director and president of the OPC. The revised corporation code also designates or requires the designation of a nominee and an alternate nominee in the articles of incorporation who shall replace the single stockholder in the event of the latter's death until the legal heirs of the single stockholder have been legally determined and the heirs have agreed among themselves who will take place the decease, and also in case of incapacity. Now, the nominee can take over the management of the OPC as director and president. At the end of the incapacity, the stockholder can resume the management of the one-person corporation. However, the written consent of the nominee shall be attached to the application for incorporation. The OPC shall appoint a treasurer, a corporate secretary, and other officers within 15 days from issuance of its certificate of incorporation by the SEC and notify the SEC within 5 days of this appointment. The single stockholder shall not be appointed as corporate secretary but may assume the role of a treasurer. What documents are needed to form a one-person corporation? The OPC is not required to submit and file its bylaws, unlike other corporations. The only document that is needed is the Articles of Incorporation in accordance with the requirements of the Revised Corporation Code. Now, the Articles of Incorporation must set forth the corporation's primary purpose, its principal office address, term of existence, names and details of the single stockholder, the nominee, and the alternate nominee, and the authorized, subscribed, and paid-up capital and such other matters consistent with the law and which may be deemed necessary or convenient by the Securities and Exchange Commission. Now, let's see what are unique about a one-person corporation. Number 1. Bylaws are not required, unlike in a regular corporation that must have a bylaws. Number 2, the OPC is not required to have a minimum authorized capital stock except if there is a law requiring one. Third, no portion of the authorized capital is required to be paid up at the time of incorporation unless of course there is a law requiring that to happen. And finally, the OPC must submit the following documents as reportorial requirements. Number 1, the audited financial statements within 120 days from the end of its fiscal year as indicated in its articles of incorporation. Now, if the total assets or liabilities of the corporation are less than 600,000 pesos, the financial statement shall be certified under oath by the corporation's treasurer. Number 2, a report on all explanations or comments by the president on the qualification, reservation, or adverse remarks made by the auditor in the financial statements. Number 3, a disclosure of all self-dealings and related party transactions entered into between the OPC and the single stockholder. And number 4, other reports as the Securities and Exchange Commission of the Philippines may require. So right now, we have now discussed the new entity in the Philippines called a one-person corporation or an OPC. Thank you for watching this video. If this was helpful to you, please subscribe to our YouTube channel. Please also like our Facebook page, Nicolas and the Vega Law Offices. Finally, I am inviting you to visit our website, ndvlaw.com, for more articles and information about Philippine law. I am Atty. Karlo Nicolas of Nicolas and the Vega Law Offices. Thank you.